Greetings to you all. My name is Marian Tafans Gonyarwanga, and I am a law student based at Herbert Chitepo School of Law, Great Zimbabwe University, Masvingo, Zimbabwe. I am here today with my presentation, which is based on the breach of contract under the law of contract. The main aim of this presentation is to provide some radical thinking, is to provide some innovative insights, and to give viewers a compass in the subject of contract law. It is also the aim of this presentation to show some contractual principles, legislation, and case law through a comprehensive analysis. So generally, the law of contract in Zimbabwe and the world at large is used in commercial, business, and corporate transactions. It is applied because it provides some basic principles to follow when parties are entering into any sort of agreement. By definition, a contract is a legally enforceable agreement between two parties that creates a mutual obligation. It can either be expressed in oral or written form. A contract can either be bilateral, multilateral, and unilateral in nature. It is also important to note that a contract has got some essential elements, and these essential elements are the ones that makes a contract to be legally binding. These essential elements, they include offer, acceptance, mutuality of obligations, consideration, competency, and capacity. The aim of each and every contract is to create a binding obligation between legal persons, and each and every party must fulfill his or her contractual obligations. Now, the million-dollar question that arises is that what happens if another party fails to carry his or her contractual obligations? Food for thought. This is where we start to look at what is a breach. A breach simply means an unjustified failure to perform any of the agreed terms and conditions of a contract. One can breach a contract by failing to pay on time, failing to deliver goods or services, failing to complete a job, and also providing some inferior goods. If a breach has occurred, and if a plaintiff wants to sue the defaulting party, he or she must prove the elements of a breach of a contract in order to win the case. So if a plaintiff wants to sue the defaulting party, he or she is required to prove the elements of each of the breach of contract claim. These are proving the existence of the contract, proving that he or she performed the obligations, and also proving that the other party has failed to perform part of their contract. Breach of contracts comes in two forms, or there are two types of contract breaching. These are anticipatory breach of contract and also the actual breach of contract. So I'll start by taking a look at what is an anticipatory breach of contract. An anticipatory breach of contract, as the name suggests, it is the breach of contract before the time of performance. It occurs before the time fixed for performance has arrived, when the promisor refuses altogether to perform his or her promise and signifies his unwillingness even before the time of performance has arrived. It is called an anticipatory breach. It can either be in spoken or written words. I want to give an example of a situation whereby an anticipatory breach of contract can happen. Let's take for instance, an architect makes it impossible to meet a deadline. That is, they stop working on the current project and take all their resources into another new project with a new developer. The first developer would have the cause to take some legal action against the architect because an anticipatory breach of contract has already occurred. I'll move on to the next type of a breach of contract, which is my favorite, and this one is called the actual breach of contract. The actual breach of contract, this occurs when one party refuses to fulfill his or her side bargain on the due date or performs the contract incompletely. The actual breach of contract can also be defined as the failure to meet obligations stated in a contract. The law bounds each and every party to perform his or her contractual duties. But if one of the parties refuses, what happens? The other party in the contract obtains a right of action against the other party who has refused to perform the contract. It is also worth noting that the actual breach of contract may be committed at the time when the performance of contract is due and also during the performance of the contract. I will give an example of what an actual breach of contract looks like. I'll give a scenario. Let's take, for instance, Marian agrees to deliver 100 bags of sugar to Mr. Chimuti on the 21st of December 2020. But on the said day, Marian fails to supply it. This is the actual breach of contract which has been committed by Marian at the time when a performance becomes due. So I'm now done with the types of breaches of contracts, and please do not be limited. Yes, there are various types of contract breaching. I will now move to the defenses. In contract law and under the topic of breach of contract, defenses are available to an innocent party whenever there is a breach of contract. If there are reciprocal obligations in a contract whereby the contractual parties have got the rights and obligations, an innocent party, not the defaulting party, may withhold his or her obligations or performance in order to force the defaulting party to perform. This is called the principle of reciprocity. The principle of reciprocity. So, for the defense of the principle of reciprocity to succeed, it must fulfill some of the requirements. For instance, the defendant's performance, it should be reciprocal, and the plaintiff's services or work should be incomplete. So therefore, if all the elements are met, therefore the defense succeeds. I'll move on to the remedies that are offered when a contract has been breached. The purpose of contract remedies, for the most part, is to compensate the non-breaching party for the losses suffered. There are a variety of remedies that are available for a contract breach. The appropriate compensation or the remedy, it all depends upon the circumstances. The non-breaching party, which is called the innocent party, you will need to demonstrate that the other party failed to perform in order to be entitled to any type of remedy. When the breach of contract occurs, the innocent party has got the right to either keep or proceed with the contract or terminate it and claim the appropriate measures from the court. So the remedies that are available for the breach of contract are classified into two. The first remedy is meant for an innocent party when he or she chooses to abide by the contract. Then the other remedy which is available is for the party that chooses to either abide or cancel the contract. The examples of the contractual remedies for a breach of contract, they include the monetary damages, the specific performance, the interdict, rescission, and the liquidation damages. So I will first explain one of the remedies, which is called the specific performance. The specific performance is the primary and the natural remedy for the breach of contract. This kind of remedy, it emphasizes on the performance of the contractual obligations. Although the plaintiff can claim some specific performance from the defendant, the court has got a discretion to either grant or decline the order of the specific performance. The court can also refuse to grant this decree of specific performance where the order would cause great hardship on the defaulting party or at the public. Now, the case of Haynes versus King Williamstown Municipality, 1951. In this case, the plaintiff had entered into an agreement, right, with the respondent company in which the latter was going to deliver certain quantities of water to her. But due to an unprecedented drought, the respondent company defaulted. She sought a decree of specific performance, but the court refused it. And the court held that the supply of 250,000 gallons of water would create hardship on the community as the dam level had dropped. Therefore, the order of specific performance was denied based on the hardship that existed. So we can see that this type of remedy, which is called the specific performance, it is the right of the court to either accept it or decline it. So I am now done with the remedies of the breach of contract. And therefore, to sum up this presentation, it is important to note that the law of contract is diversified in nature. And part of this presentation is managed to define the breach of contract, how the breach of contract can be proved, the defenses that are available to an innocent party if there is a breach, and also the remedies that are available when there is a breach. It is my hope that the presentation has managed to provide some radical thinking, and it has also managed to provide some innovative insight through a comprehensible analysis so as to give viewers who are either law students or non-law students. And this presentation, I really hope it has also benefited some of the citizens of Zimbabwe and the world at large, since it has given us a powerful compass in the subject of the law of contract. Good day.